Over time, you may have noticed a number of your favourite copyrighted works display the copyright symbol followed by the name of the copyrighted work's creator and its year of creation. This is known as a copyright notice, and you may find yourself wondering why they are used to identify copyrighted works. To understand why, it's first necessary to understand the origin of the copyright notice, how it is used in Australia, and what legal purpose it serves. The use of copyright notice began as a result of Article 3 of the Universal Copyright Convention of 1954. If a country ratified this convention, they were required to make notice of copyright by having the original work bear the copyright symbol, the creator of the work, and the year of first publication. This requirement was one of the major differences between the Universal Copyright Convention and the Berne Convention. The Berne Convention of 1884 set out three basic principles that must be enforced by any contracting state. Firstly, any work originating in a contracting state must be given the same protection across all contracting states. Secondly, copyright protection is not conditional and will be automatic. Receiving copyright protection is not reliant upon complying with any formalities, such as the formality of having to provide a copyright notice. And thirdly, copyright protection is independent of the existence of protection in the country of origin of where the work was created. That is, copyright protection may be denied through all contracted states where the work ceases to be protected in the country that it was made. Since 1928, Australia has been a member of the Berne Convention, meaning copyright is provided automatically and does not rely upon any formalities. However, the Copyright Act 1968 considers the effect of using a copyright notice. Section 126A, subsection 2 of the Copyright Act 1968 provides that any copyrighted work marked with the year of first publication is presumed to have been published in that year unless the contrary is established. Section 126B, subsection 2 of the Act provides that any copyrighted work marked with the name of the publisher is presumed to have been created by that person unless otherwise established. The purpose of including the year of the first publication is to indicate the expiry date of the copyright. In Australia, copyright may exist on works for a period of between 25 and 70 years, depending on whether it is a Part 3 work or a Part 4 work under the Copyright Act. Part 3 works, which include literary, dramatic, musical, or artistic works, may be copyrighted for a period of 70 years after the death of the author if it has been published, and up to 70 years from the date of first publication for unpublished works. And for Part 4 works, they will expire either 70, 50, or 25 years from the date of first publication. In summary, copyright in Australia is automatic. However, use of copyright notices is not discouraged, as they help indicate when copyright protection will cease to operate. While not serving a legal purpose, copyright notices serve the purpose of providing important information to the public.